I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm filling up parking now. It seems like you're practicing law from the bench. I'm going to respect your courtroom, but I disagree. Yes.
Sir, you have to stop interrupting.
Penalty and perjury.
If you stop speaking when I'm speaking.
Your Honor, he's coercing. And since there's no statute of limitation for fraud, he's wasting judicial resources. Honor my counterclaim to dismiss this matter.
So based on the proofs on the record, the court does find that.
All right, folks, today we're looking at a courtroom moment featuring one of the most frustrating sovereign citizens we've seen in a while. Judge Hillman takes a different route this time. Rather than shutting things down right away, he tries to remain calm and patient. It definitely makes for an interesting watch. But here's something to think about. How long should judges allow this kind of behavior before stepping in more firmly? In my view, the judge could have been a bit more direct, but I won't give too much away. Let's jump in and see how this situation unfolds.
You said I'm driving a vehicle. Yeah, you need me to stop? I
need you to stop, sir. I can't have you driving while you're.
Give me 15 seconds. I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm filling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record. When I appeal this, if this don't go accordingly.
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I would disagree as tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Dooher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my ground.
This is one of the biggest issues I see with how some judges handle sovereign citizens. In cases like this, they really need to be more assertive. Now, don't get me wrong, this judge seems like a decent person, but he's being way too patient here. It's pretty clear the man in court is stalling and taking advantage of that. Patience. And honestly, by now, the judge should have at least warned him about possible contempt. It's frustrating to watch someone stretch things out like this without consequences. I don't know about you, but it seems obvious to me that this guy isn't being serious. He's just trying to waste time. Let me know your thoughts, and let's get back to it. Hopefully, the judge puts a stop to it soon.
And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment. to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your
objection.
Honor, you don't have my deed of records right there. You don't have me as the deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
As a government record and or document recorded with the applicable recorder of deeds for this this document.
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no firsthand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company? Okay,
so the objection is that this witness doesn't have the
firsthand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they are real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if they are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that...
Thing I just can't wrap my head around in this hearing is why, with so much at stake, this man thought it was a smart move to represent himself. I mean, his home is literally on the line, and instead of hiring an attorney, he decided to go it alone and keep shouting objection like that would magically fix everything. That's just not how the legal system works. Yes, the Sixth Amendment gives you the right to a lawyer, and there's a reason for that, because the law is complex. Watching a few videos online doesn't make you a legal expert. Honestly, it's hard to understand why someone would risk everything just to make some strange point. What do you all think? Can you imagine a situation where this actually makes sense? I've seen a lot of these cases, and I haven't found one yet. But anyway, let's jump back in.
I got the taxes in my name. I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Okay.
He said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson,
let me know when I'm credible to ask questions.
All right, Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst. Is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, object as to relevancy.
Again,
okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No,
So
I'm not trying
you
to.
have
I'm asking a question. That was
You
a
have a
question.
question regarding the facts for
Yes.
Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice, that I sent with behalf of Matthew Brown and Rachel Brown, that they're yet to respond from? My notary sent it. The Notary Republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr.
Okay,
Johnson, what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but, you know, I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the Business and Record Department, and I sent it attention to the CFO of the company.
That's an argument. That's not a question. This is a time for questions.
It's honestly past time for this guy to get a lawyer. Watching this is tough. And even the judge's patience is starting to feel a little too generous. At what point do you just call it and take control? He said objection more than 30 times now, and not a single one has actually applied to anything. It almost feels like he thinks repeating it enough will somehow win him the case. But let's be real. Contempt of court exists for situations exactly like this, when someone refuses to follow basic courtroom rules and just keeps dragging things out. At this point, the court needs to either consider a contempt charge or evaluate whether he fully understands what's going on, because something just isn't adding up. What do you think? Would you have stopped this already or let him keep going? Also, if anyone's been counting how many objections he's thrown out, let me know.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter, if you have that in the record? So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
under
sure.
penalty and perjury, do the company have it, Mr. Dewhurst?
So you may ask another question.
And also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all gap procedures with this process?
Objection, Your Honor.
So I guess the last question, again, I just want him to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Asked and answered.
No, that's not asking to answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking you that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if Your Honor or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
and this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources.
The plaintiff is clearly wasting the court's time. And honestly, it's hard to tell if he's just completely unaware or if he's doing this on purpose to delay the case. He's the one dragging everything out while the judge, attorneys, and court staff are all stuck dealing with the chaos. And let's be honest, we know exactly why he's doing it. He's trying to stall, hoping that somehow delaying things will make his legal problems go away. But that's not how the system works. The court isn't going to drop your case just because you keep repeating objections or refusing to follow the rules. What really stands out with many sovereign citizens is how they demand their rights but forget that responsibilities come with them. The law is pretty straightforward. If you clog up the system with nonsense and ignore proper procedure, that's on you. But accountability doesn't seem to be a concept they take seriously. What do you all think? Is he really this lost? Or is he just playing games with the court?
Coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession, and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you,
Your Honor.
This guy honestly seems disconnected from reality. I mean, he really looked the judge in the eye and confidently said he'd just appeal and get the ruling overturned, like that's some kind of guaranteed shortcut. That's not how the appeals process works. Appeals courts don't just redo a case because someone didn't like the outcome. They only step in if there were clear legal errors, like if a judge ignored the law or violated someone's rights. Otherwise, you're just wasting more time and money. Honestly, reality is about to hit him hard. And I think the judge could have been firmer here too. Maybe I'm being tough on the judge. Let me know if you think I'm off, but I really believe he should have put his foot down sooner. Still, this whole situation was a perfect example of what not to do in a courtroom. If you ever find yourself in legal trouble, please don't take notes from a sovereign citizen. That said, the judge's patience was impressive. At the end of the day, the law won't bend just because someone refuses to accept it. You can argue all you want, but the system doesn't follow made-up rules. It's like denying gravity. It won't stop you from falling. Anyway, I'll wrap it up here. Let me know in the comments. Do you think this guy was just trolling the court, or did he actually believe he had a chance? And if you enjoyed this video, make sure to like and subscribe. I post new content every day. Thanks so much for watching, and take care.